My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. But what happens if the executor of an estate refuses or fails to distribute estate property to the beneficiaries? Well, first of all, the executor owes a fiduciary duty to the beneficiaries, and that has been called the highest duty under the law. But in my experience, a lot of executors and even trustees are not professionally trained, don't understand the duties and obligations, and oftentimes they see it as a position of power. I'm the executor, I'm in charge. Well, that is completely the wrong attitude, because they are going to have to explain to a judge or potentially a jury at some point how they put the interests of the beneficiaries above their own interests. In reality, it is not a position of power per se. It is a position of obligation, and legally they essentially have a target on their back if they fail to act properly. But unfortunately, I see it a lot. So what happens when I get a call from a beneficiary or maybe a group of beneficiaries to say, hey, the estate's been open several years, maybe 3 years, maybe even as long as a decade, and they've received minimal or maybe no assets and distributed. So what do we do? Well, first of all, the Texas Estates Code, section 360.301, imposes liability upon an executor who fails to deliver estate assets. That's really just a recapitulation of the common law duty of a fiduciary. But typically, what I do is first send a demand letter to the executor's attorney demanding an accounting under section 404.001 of the Estates Code. What that section provides is a beneficiary, as an interested person in the estate, can send a formal demand for an accounting to the executor, and they have 60 days to respond. And it's not simply just a listing of assets in the estate, but the assets that they have come to receive, the expenses of the estate, the income of the estate. It is fairly formal, the accounting that's required. What happens if they don't provide the accounting? Well, the next step is file a motion to compel accounting with the court. They will then have to come forward and explain to the probate judge why they have failed to provide an accounting or why it's in some way inadequate. And depending how old the estate is, the judge is not only going to order the accounting, but quite likely have some very hard questions for the executor as to why the assets have not been distributed. Feel free to give me a call if you're having an issue with the estate in Texas.